Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving solicitors' undertakings, a key topic in professional conduct under both FLK1 and FLK2. Let's dive in. During a commercial transaction, a solicitor had a telephone conversation with the opposing party's solicitor. In that call, they agreed that the solicitor's client would make payment after completion of the transaction, once the funds had cleared. The solicitor stated his intention to send a confirming email, but due to a heavy workload, the email was never sent. In this situation, can it be considered that the solicitor provided an undertaking? A. No, as the agreement was only made verbally. B. Yes, as undertakings may be made verbally. C. No, the agreement was not confirmed by email. D. Yes, as the agreement was made with another solicitor. E. No, as the agreement was not expressly an undertaking. The best answer is B. Yes, as undertakings may be made verbally. In professional conduct, a solicitor's undertaking is a solemn promise or assurance given in the course of legal practice, which is binding and enforceable by the court. Undertakings can be verbal and do not need to be in writing to be valid. They are enforceable if given by a solicitor in his capacity as a solicitor, particularly to another solicitor, and the terms are clear and unambiguous. The failure to send a confirming email does not invalidate the undertaking if the verbal promise meets the criteria. An undertaking can be implied from the words and conduct of the solicitor, even if they don't use the word undertake. In this case, the solicitor gave a clear assurance to another solicitor that payment would be made after completion. This is sufficient to amount to an undertaking, even though it was made verbally and not later confirmed by email. Scenario 2. During a commercial transaction, a legal assistant at a law firm was instructed by his supervising solicitor to inform the opposing party's solicitor that their client would ensure payment after completion, once funds had cleared. The legal assistant made this statement during a phone call with the other side. No written confirmation was sent, and the supervising solicitor did not personally speak to the opposing solicitor. In this situation, can it be considered that a valid undertaking was given? A. Yes, as the legal assistant was acting on the solicitor's instruction. B. Yes, because the statement was made during a legal transaction. C. No, because the undertaking was not confirmed in writing. D. Yes, because any employee of a law firm may bind the firm with an undertaking. E. No, because only solicitors can give undertakings on behalf of the firm. The best answer is E. No, because only solicitors can give undertakings on behalf of the firm. This is based on the fundamental principle that undertakings are personal professional obligations that can only be given by qualified solicitors. The SRA Code of Conduct and established case law make clear that undertakings are personal promises by solicitors that create professional and disciplinary obligations. They cannot be delegated to non-qualified staff. Scenario 3. A solicitor acting for a client in a company acquisition gave the following written undertaking to the opposing solicitor. We undertake to provide the signed share transfer forms and board resolutions within 24 hours of completion. Shortly after giving the undertaking, the client informs the solicitor that they no longer wish to proceed with the transaction and instructs the solicitor not to release any documents to the other side. The solicitor now realizes they cannot comply with the undertaking without going against the client's new instructions. What should the solicitor do? A. The solicitor should immediately notify the other side that the undertaking is revoked. B. The solicitor must comply with the client's new instructions and not to comply with the undertaking. C. The solicitor remains bound by the undertaking unless the opposing solicitor agrees to release it. D. The solicitor should apply to the court for permission to vary the terms of the undertaking. E. The solicitor can unilaterally withdraw the undertaking before the 24-hour period expires. The best answer is C. The solicitor remains bound by the undertaking unless the opposing solicitor agrees to release it. This is based on the fundamental principles governing solicitors' undertakings. Undertakings are irrevocable, Once given, a solicitor's undertaking creates a binding professional obligation that cannot be unilaterally withdrawn or revoked by the solicitor who gave it. Personal obligation. The undertaking is the solicitor's personal promise, separate from and independent of the underlying client retainer. It doesn't cease to exist simply because the client changes their instructions. Release requires consent. The only way to escape the undertaking is if the party who received it, the opposing solicitor, agrees to release the solicitor from the obligation. Professional consequences. Failure to comply with an undertaking is a serious professional disciplinary matter, regardless of client instructions to the contrary. This table illustrates the key principles governing solicitors' undertakings. First, an undertaking can be valid even if given verbally, provided it is made by a qualified solicitor in the course of legal practice, using clear and unambiguous terms. There is no requirement for it to be in writing or to include the word undertake. Second, only solicitors or authorized legal professionals may give binding undertakings. They are personal professional promises and cannot be delegated to non-qualified staff such as legal assistants. Third, once an undertaking is given, it is binding and cannot be unilaterally revoked, even if the client changes their instructions. The solicitor remains personally liable unless the recipient of the undertaking agrees to release it. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.